Welcome and thank you for being here. And please feel free to state your name for the record and proceed.
Thank you very much. My name's Stephen L. Mikochick. Okay. Oh, there it is. Okay. Can you hear me?
Yes, your microphone is on. Thank you so much, sir.
My name's Stephen L. Mikochick, and I'm an emeritus professor of constitutional law at Temple Law School in Philadelphia, and I'm a visiting professor of jurisprudence at Ave Maria School of Law in Naples, Florida. And in some past life, I was an attorney and a disability expert for the Civil Rights Division, U.S. Department of Justice. I'm here at the invitation of the Family Institute of Connecticut, and I'm here to testify against House Bill 6645, which, in my opinion, is an uncommonly bad bill. There are two issues that I'd like to briefly touch on. One is the deficiencies in the bill, and the second is whether the bill can be improved. Concerning the deficiencies, Senator Meyer, who I understand is a principal sponsor of the bill, identified himself some of the deficiencies in earlier testimony, and I need not repeat it. But if you look particularly at the waiver provision in Section 7B, it is literally possible that at the time that the patient receives the initial diagnosis of a terminal condition, that patient can have a lethal dose in hand that day. There is no set requirement for consultation. It can be waived under 7B. The attending physician has to refer for a psychiatric or psychological evaluation if there's an indication of clinical depression. There is no requirement that that attending physician have any training in identifying clinical depression. There is a requirement that the attending physician evaluate the competency of the person requesting the lethal dose. There is no requirement, if you look at the definition of attending physician, that that physician be really familiar with the patient's history and background. All it requires is that the attending physician be in charge of the terminal care. It could be a specialist that just has seen the patient once or twice. And even the witnesses to the written request don't have to have familiarity with the patient. For example, they can attest to the document based on receiving an ID that this is really the person who is representing that they are. All right, so there are clearly serious problems. I assume the bell tolls for me.
Well, please proceed and summarize some more of your testimony.
Let me then go to the main issue, which can the bill be rehabilitated? And I think the answer is simply no. It is a recipe for elder abuse. There is no requirement that at the time the individual patient, the elderly person, ingests the medication. Ingest doesn't mean take it and put it in your mouth. Ingest means swallow. So you're bridging the gap, by the way, using that definition between assisted suicide and euthanasia. There is no requirement that there be an objective witness, an heir who would benefit from the estate if the individual died. Not only can attest to the statement where the individual is requesting the lethal dose, but be the only witness present at the time the drug is taken. There is no requirement at the time the drug is taken that the individual patient be judged to be competent. Senator Myers ended his testimony by saying that section, I believe, 16 of the bill indicates that anyone who coerces someone to take a lethal dose commits murder. How can you prove that under this bill? There is no requirement for an objective witness. There is no requirement, even if you take the definition of self-administer as it stands, which is merely the swallow, that the patient involved take the medication and give it to themselves. And the physician is required to falsify the death certificate and say it was the underlying condition and not the lethal medication that was the cause of death. If there was coercion of a frail elder who decided at the last moment she didn't want to take the medication, how could you prove it? Thank you very much.
Thank you. Are there any
Are
questions?
there any questions I can answer?
Yes, Senator Walsh.
Thank you, Madam Chair. So I guess the first thing I want to do is understand what it is you just said, because that's not something I've thought of. And if I'm stating this correctly or incorrectly, please let me know. And that is, you're saying as the bill is written, it requires that the individual be competent at the time they tell their doctor.
Or at least the physician says that they're competent.
You're right. You're absolutely right.
Right.
The physician says they're competent at the time that they ask for the prescription, but there is no secondary analysis done at the time they actually ingest the pill.
If it's there, I haven't seen it,
Okay.
and I've read the bill a number of times. It simply isn't there. By the way, it's not there in the Massachusetts legislation that the good people of Massachusetts decided was also uncommonly silly, and they rejected it.
Well, then I guess that leads me to maybe my next question, and it sounds like you're familiar with some of these laws elsewhere. Mm-hmm. To what extent does the bill before us differ from what we see in Oregon, what we see in Washington?
Oregon, Washington, the Massachusetts bill that was defeated all had essentially a 15-day waiting period. I would submit to you that even the 15-day waiting period is insignificant. Just think about how long it would take someone to digest the fact that they had a terminal condition. You wake up from a car accident and the doctor tells you, it looks like you may die within the next 6 months. Do you think it's going to take 15 days for you to be able to make a rational decision again? Let alone 1 day, which is what your bill provides?
Well, then, if I may, through you, Madam President, and so that's kind of one of the concerns I have is what does it mean to be competent, and to what extent does or does not depression impact a decision or finding of competency? And I don't know based on.
Can I address that? I'm sorry.
Sure, absolutely.
If you look at the seminal Supreme Court decision in 1997, Washington versus Glucksberg, where the Supreme Court said there was no substantive due process right to die, one of the things that Chief Justice Rehnquist wrote for the majority on was that about 95%, he said, of all people who attempt suicide are clinically depressed. Many, if not most of them, if they receive adequate treatment, recount the request for suicide. All right? That many doctors aren't trained in actually identifying clinical depression. So it becomes very important that there be an adequate determination of whether the person is in fact clinically depressed. It is odd to me, Senator, that if somebody is charged with a capital offense and raises an insanity claim, we almost automatically determine whether they're competent to stand trial. And we don't do that by the judge kind of sitting over and saying, you look competent to me. What do? We send that person for psychiatric and psychological evaluations. Why do we do that? Because life is precious, and we don't want to take it away unless we absolutely have to. Why is it that we afford that process to people accused of capital offenses? For that matter, why do we have witnesses at executions when prisoners receive lethal doses to ensure that it's done in a humane way? But this bill neither requires a psychiatric evaluation, nor does it require an objective witness at the time the medication is taken.
Now, it sounds like you've had experience advocating with justice, or on behalf of justice, on behalf of persons with disabilities. And I don't know to what extent you've been working with that community with respect to this bill and bills like this. But I'm assuming you've heard the testimony this morning about individuals with disabilities being concerned about how they go in and out of terminal illness, or in and out of, I'm inartfully saying this, but at times their conditions appear terminal, at times they're not terminal, and then also the fact that their emotional state changes because of their disability at times. And I don't know to what extent you've had experience dealing with individuals like that, and would care to comment on the first-hand experience you might have?
Well, let me structure this for you and see what you think. What's the policy reason why states like Oregon or Washington State have recognized assisted suicide for terminal patients? I think the policy reason is based on the recorded reasons why people in those states have requested assisted suicide. The two principal reasons seem to be because they don't want to be a burden to their families, and they don't want a loss of dignity and autonomy. But disabled people are socialized to feel the same way, that they're a burden on their families, that because of the disability they've lost dignity and autonomy. If we're going to say to somebody with a terminal condition who's expected, and of course this is subject to a lot of variation, I mean, one can't bank necessarily on a diagnosis that the person will die in 6 months, but let's assume for the sake of argument that the prognosis is accurate. And we sit down and say, look, isn't it awful for this person to feel a lack of dignity and self-respect for this 6 months period? Let's let them, instead of getting the love that they need for their dignity from their family, let's let them kill themselves because they think nobody loves them, all right? Because we don't want them to endure the 6 months. What about the disabled person who's enduring these problems for 60 years? Isn't there a stronger reason to provide that lethal dose to the disabled person with a severe chronic disability? And why should we limit it to the disabled person with a physical disability? What about a disabled person with a severe psychiatric disability? And what about a disabled person who's unable to take the medication and put it to their mouth? Is it fair to disadvantage them? After all, we've given the right to other people. Right? And what about the disabled person who's never been really communicative? Can't we assume that nobody would live in his condition, and that if he could speak, he'd want to take this medication? And what about the disabled person who says, I don't want it? Well, you can't be rational to say you don't want it, living in that condition. If you were rational, you would want it, so we're going to give it to you anyway. That's what happened in the Netherlands. That's what could happen here.
And I guess through you, Madam President, I just have one more question, Madam Chair, and that is, do the other states' statutes require that the individual seeking physician-assisted suicide or compassionate aid in dying, did they require that they have a terminal illness?
As they stand right now, they do. Washington and Oregon did. The legislation that was defeated in New Hampshire, I think it was 3 years ago, said that the condition must be incurable and in reasonable medical judgment would result in premature death. I assume that would include Parkinson's disease. I would assume that would include diabetes. I would assume that would include muscular dystrophy. So in New Hampshire, there was this beginning process to do what I think was always intended, to use terminal condition as the first step, but eventually extend it to include other disabling conditions. Remember, a terminal condition is a disabling condition. I mean, think about federal law. It says a disability is, a major an impairment, physical or mental, to a major life activity. Clearly, somebody with a terminal condition is also going to be disabled. So all we're doing in this legislation is we're singling out one group of disabled people, and we're saying, we, the state of Connecticut, think your lives are so less quality that we're going to offer this to you. We're going to offer you the lethal dose. Well, once we say some class of disabled people, some class of Connecticut citizens, should be treated in a less equal fashion, we think their lives are of such low quality they should have access to ending their lives. Then what stops us from extending that to another group whose lives we think also are less worthy of living?
Thank you. Thank you, Madam Chair.
Thank you. Representative Sharon.
Yes.
Thank you, sir, and thank you, Madam Chair. Your earlier testimony is quite compelling, sir. However, I learned some things. You stated that you didn't think this bill could be fixed. So my question to you would be, do you think a law or a bill could even be written to address the compassionate reasons why this bill is before us today?
Yeah. The compassionate reasons would be, look, there is no requirement in law, and I think it would be questionable constitutionally, for law to require that an individual continue with life-sustaining treatment. So if an individual felt, for example, that he didn't want to continue with a respirator, I don't think Connecticut law or any state law can require that. All right? But that's not the state coming in and saying that we're offering you the opportunity to die. It's the state coming in and saying, look, based on our common law tradition, government can't enforce you to continue with treatment. Now, maybe your reason for not continuing treatment is because you want to die. But maybe it's because the treatment is very invasive. Or maybe it's psychologically repulsive to you. Or maybe it's causing ancillary complications. There could be a host of reasons why someone would decline life-sustaining treatment. But at least when the state says that we can't require you to continue with life-sustaining treatment, the state isn't saying, okay, it's all right for you to kill yourself. And that's what any assisted suicide bill says, that it's all right for this class of citizens to kill themselves.
So just to clarify then, so what you're saying in your testimony is that there is no way a bill could be written at all to get to the intent of the bill we have before us.
If there was, I assume it would have been done by now. If you look at the legislation that has been proposed throughout the United States, the same pattern is there. Whether it's the Oregon bill, whether it's the Washington State bill, whether it's the Massachusetts bill, time and again these criticisms have been raised. Time and again they've been rejected. All right, not only by Massachusetts, but every legislature in the United States that has considered assisted suicide legislation has rejected it. Once it's exposed to the deliberative and thoughtful legislative process, rather than news bites in a referendum campaign, this legislation, and if you compare the legislation, there's one template going on, has been rejected by legislatures unanimously.
And through you, Madam Chair, I had the opportunity to watch the PBS special on this issue from Oregon, and at the time they kind of followed a patient. And I was surprised to see the number of medications that are required in Oregon. And I don't know if you are aware, but can you tell me if the medication we're talking about here is the same? Is it one pill, or is it a number of series of steps like it is in Oregon?
Given the fact that the principal sponsor of the legislation couldn't respond to that in this prior testimony, neither can I.
Okay, I'm sorry, I'd stepped out. And lastly, if you could just clarify for me, sir, you mentioned that you are here at the request of the Family Institute.
Yes, ma'am.
Are you also being paid by them for your
No,
testimony?
They paid my airfare, but I'm picking up my own meals.
Great, thanks for your honesty, and thank you, Madam Chair.
Thank you so much. Okay, any additional questions? Thank you so much for your testimony.
Thank you very much, Chair.